I think there are about 15 of us. So what we are going to do is just try to recap on what we did at our last physical class, while the remaining students will be joining in, I hope. Can somebody, we started off with the legal sources of law. Can someone assist us with a recap of what we did at our last class? I hope you are getting the slides.
Yes, sir.
Can someone help us to recap on what we did? The slides will give you a hint. We are a little slow today. Is it because of the preparation for Salah? Hello?
Yes, sir. We're already in holiday mood.
So, sir.
I'm in holiday mood too, but I have to work. Okay, so we'll do a little recap. I'll do that by myself. I hope that people that are not in holiday mood will join us as we go on. Now, we said we were going into the sources of law, and we named 4 main sources of law. First of all, anyway, we said that there are 2 types of sources of law. We have the legal source and the historical source. Who can explain the legal source for us?
Okay. So I said the legal source of law is one that has valid authority within a particular jurisdiction for the time being.
Thank you. One that has a valid authority within a particular jurisdiction, where that particular jurisdiction has, number 1, recognized that particular source of law. It has not only recognized it, it has applied it, and it has accepted. The judicial system also accepts it and then applies it as of right. Now, the moment that those 3 processes are being done, then what you have is a legal source of law, because it is being applied as of right. It is not being called into court for proof. Now, the second one is the historical source, and we also discussed about what a historical source of law will be. And we said historical source of law obviously will be any source of law that is not in force for the time being, and we usually have just persuasive effect. And we talked about the laws of other jurisdictions, right? We talked about things like the laws of other jurisdictions, not just the laws of other jurisdictions. We also talked about the different statutes or so that may be applied as of right in specific jurisdictions, even within a particular domestic legal system. I think that was when we talked about whether, if you run, for example, a bicameral legislature like you run in Nigeria, and then you have specific matters that are reserved for a specific layer of legislature. Take, for example, you have something in the exclusive jurisdictions that is exclusive to maybe the state legislature, and others are exclusive to the national legislature. Now, if the national legislature makes a law, then that law within its exclusive jurisdiction will be a legal source of law, right?
Yes, sir.
And we talk about, when we're talking about if you have a bicameral legislature, the import basically is, now if you have the concurrent jurisdiction where both the state and the federal legislatures can make law relating to a particular matter, such as, say, taxation, for example, or the environment. And we said the national legislature, the national legislation will take precedence in cases of conflict between the state legislation and the national legislation. We said that, right?
Yes, sir.
And we said these parts of the state legislation, for example, that do not suffer from conflict with the national legislation can still be termed as what? A legal source of law, right?
Yes, sir.
While the one that suffers conflict will be a historical source of law. And we also talked about something like Jeremy Bentham, for example, could have sat down, written a whole thesis on a particular matter. He could have derived that thesis from, say, Roman law or the views of other writers. Now, all those things will be termed historical sources of law because they are only of persuasive effect in any at any rate in a Nigerian court. And then we also talked about, I'm not sure if we said this, but the Privy Council, for example, is like the Supreme Court for the colonies. And for the Supreme Court of the colonies, it was only of persuasive if it was a legal source of law, for example, for the colonies, but a historical source of law for courts in Britain. I hope you are getting that.
Yes, I will see, sir.
Okay, and then we now went into the types of legal sources. And we said legislation, for example, is recognized as a source of law. But let's get this straight. Just the fact that it's legislation does not make it a legal source of law. It can be historical and it can be legal. The fact that something is a judicial precedent does not make it a legal source of law. It can be a historical source of law. It depends on whether it is being used, whether that particular source is being used and being regarded as authoritative, where courts are bound to follow. So we talked about, we said there are 4 different sources of law. There's legislation, there's judicial precedent, you have customary law, which has the source in custom, and then conventional law or agreements. I hope you understood. I'm assuming that the holiday thing should have ebbed from your body now and it should be sharper.
I understand, sir.
Now for legislation, we said that there are that you have the supreme legislation and the subordinate legislation. Can someone explain that for us?
Good morning, sir.
Good morning.
Sir, if I would make an attempt, sir.
Please.
Supreme
Good morning, sir.
from the legislature, why the subordinates emanate from other bodies that are given powers by the legislature to make laws on certain areas.
Okay. Second guy.
Yes, sir. Can you hear me, sir?
I can hear you clearly.
Yes, sir. So, like she said, the supreme legislatures are the ones that emanate from the legislatures, that is the body that is vested with the power of making law, while the subordinate ones are the ones that are delegated to so other bodies who, although they do not have the functions of making laws, but then to regulate some of the technical aspects of their functions, then they are given the power to make laws to guide those things. So,
Okay. Obviously, we talked about colonial legislation, which is a different type of legislation from what we're talking about now currently. Because colonial legislation, some of them still exist in Nigeria by virtue of our law that states that those that were in operation before the 1st of January, which year was that?
January 1st,
1900.
January 1st.
1900.
Okay. So many of those laws are still in force currently as we speak. Now, for executive legislation, it's a different type of subordinate legislation. And the reason is this, because there is what you call delegated legislation. It generally will be delegated legislation that is delegated by the legislature to the executive for several reasons. Can someone tell me one of those reasons? Why do legislatures delegate legislation?
Because they can't do it all. And the other area which they are not experts in, so they have to delegate their powers.
Thank you very much. That's a perfect response. Number one, they can't do it all. They are not jacks of all trades. You'll find out that most of the legislations that they delegate to the executive, for example, will be the kinds of legislation that require constant appraisal, which means the executive being the particular part of the executive being in that industry or that area is constantly aware of growth and is coming up with regulations in respect of the progress of that particular subject matter. Take, for example, if you were to have a ministry, for example, of which part of its remit is the extinction, they deal with endangered species. And if you're talking about the endangered species, some of the things that cross your mind is, what are we talking about here? Who knows an endangered species in Nigeria? Can someone tell me an endangered species in Nigeria?
Oh, so are you talking about like animals or
An animal,
in
yeah.
general? Let's use ram.
Ram is not endangered though.
Elephant.
Are you sure?
You can probably have as much ram as you want. But now the reason you went into ram basically is because tomorrow is Salah and you're already salivating, right?
Yes,
but
yes,
the common Nigerian will be absolutely unaware regarding what species is on the verge of extinction in this country. I'll give you one example. There are clamors up north for the protection of the donkey. As a matter of fact, there are members of the House that are working seriously with even shelters and things like other organizations from outside of the country, making reports and all that for protection of the donkey, because that is one of the primary ways of transportation by farmers in the north. Now, I think some pharmaceutical companies also have found out that there are some benefits from the fat of the donkey, and because of that, some countries were just coming in here to export, to set up businesses here, exporting donkeys. And a lot of the farmers just thought, well, this donkey is more useful to me dead than alive, and they were selling a lot of the donkeys, of which has put the donkey on the verge of extinction in Nigeria. Now, it becomes an endangered species. Because if you don't have donkeys in Nigeria, the whole paradigm of agriculture up north can change. And its consequence will be much felt in it. But you and I sit down here and we don't know that there's a problem with the donkey. It is the executive arm that is charged with agriculture that will know. Therefore, it behoves on, the House, what the House does is delegate those kinds of legislation where the ministry can come up with regulations saying you cannot sell this, you cannot sell this. If you are going to sell it is a so-so species, you can only sell under permission from so and so. It's the same thing with communication. It's the same thing with banking. And I think in class we talked about things like agent banking and all that, where the CBN governor comes out with regulations ostensibly under the direction of the legislature, from the power devolved and delegated by the legislature to the executive, okay? So that's the kind of executive legislation that is incidental to the particular function of that unit of the executive. And then for judicial legislation, what do we say? Anybody?
Talk about procedural rule.
High Court civil procedural rules, the perfect example for judicial legislation. Because again, the legislature will not be in a position to know the intricacies of, you can have a legislative house that does not even have a lawyer. And if they have a lawyer, the lawyer is more likely to be a politician lawyer than a practicing lawyer. And it creates certain problems. So the focus is on time, on the fact that there is a proliferation of resources in other places to be able to also understand the reasons for the reasons and the need for these regulations, and that those arms are the units of the executive can react quickly. Because what you have in the House of Assembly, for example, there will be a public hearing, there will be first reading, second reading, third reading. By the time that particular legislation comes out, it's probably belated in terms of import and importance. Because what will happen is, and I think we use the telephone, mobile phone as an example. While legislations are being made relating to texting, you can now send MMS. While that is being made, video becomes a factor. While that is being made, you are sending what? Suddenly, you can't just send MMS or videos or whatever. You can actually do financial transactions on them. So because of that, what you have will be that kind of executive legislative powers. But again, in the judiciary, it is more or less the same. When the multi-door provisions in high court procedural rules came in, most legislative houses would have been unprepared for that. But it was a way for the courts to stem the flow of cases into the courts, where cases that were not too contentious could be dealt with using the multi-door processes in the states. Okay. Now, what is municipal legislation, please?
Yes, sir. Good morning, sir.
Good morning. How are you?
Yeah, very well, sir. Thank you very much. Yeah, municipal legislations, there are regulations which are emanating from municipalities like local government councils. So like regulations, but basically they are on revenue generation.
Okay. Basically, yeah, revenue generation usually. And you found out again, most of these legislation making power will be delegated from the state houses of assembly to the local government councils. And when that is done, now this is the situation in Nigeria. Why? Because Nigeria runs a bicameral legislature, where the legislative houses that are recognized by the Constitution are the federal legislative houses and the that of the states. Now, there are some other countries where you can have a tricameral legislature, which means that whatever constitution they are using also specifically recognizes municipal legislative houses or local government houses, which means that they also have power derived directly from the constitution to make laws in relation to certain matters. So where there are those divisions in terms of what is a concurrent what do you call it? The concurrent list or the exclusive list in the schedule of the constitution, you will find out that they will also have their own particular list that is dedicated to them. Now, that's not the situation in Nigeria. For autonomous legislation, we said that the law also recognizes the ability of individuals and groups to make rules relating to their specific activities. And I think we use the Law Student Society as an example. We use them, again, some aspects of aviation as examples. We also used, in fact, for the RAM that we are buying now, you find out that most of the time they will tell you to pay ladder or something, some kind of blessing, and that is something that will be enforced by the courts, because while the rules, the agreements are supposed to govern these individuals and bodies or groups, they surreptitiously drag in third parties that are unaware. I hope we understand that.
Yes, sir.
And we said there are relative merits and demerits of legislation as a source of law, and we said it has the capacity to abrogate or abolish an existing state of things. It doesn't have to wait like customary law, like judicial precedent. Customary law has to change things using the main factor of it has to run, and the time that change comes into play has to run against human memory. Judicial precedent, there has to be a case that comes before the cause for the cause to make a specific decision. This is not the same with legislation. Legislation can act not just in terms of what has happened before. A lot of times it acts in the present and in an anticipatory manner, stopping what it thinks will happen in future. Now, we also say it allows for division of labor. And we say legislation making is the apex recognition of the legislature as a lawmaking body. And because of that, it also presupposes that other arms of government will be allied to their duties in terms of the legislation that emanates from the legislative houses. The executive is bound to execute the laws emanating from the legislative houses, while the judiciary is bound to interpret, particularly in terms of conflicts that come before it. And we said it satisfies the rule of natural justice because of the detachment of the legislature and the legislations that are being from people, from the subject of the legislation that's being made. The legislation is made in general terms. It doesn't call anybody's name or anybody's and does not react to things that have happened specifically. So because of that, it satisfies the rules of natural justice, and it is also anticipatory in nature, which again, in a way satisfies the rules of natural justice, but the anticipatory nature that it has means that it's not just about abrogating things that have happened before, abolishing an already existing state of things. It is anticipatory in the fact that it compels citizens to act in a particular manner for things that may be futuristic. I'm not sure Nigeria is already has capacities for stem cell research. There can be legislation today that governs stem cell research and other researches. So it is anticipatory in the sense that it foresees what is going to come, and then rules and regulations are made in respect thereto. Then it has superior form. We already also discussed that. And the reason it has superior form is that it uses the specificity of language to convey its rules and regulations. It is not like customary law, for example, that depends on some kind of spirit and not specific words. And it is not judicial precedent, for example, where you have to live through hundreds of law reports to be able to find a specific decision that is on all fours with a current matter in question. I hope we understood.
Yes, sir.
And for interpretation of statutes, again, we started off with the fact that obviously interpretation of statutes is governed by one major rule, which is that the statute should be interpreted in line with the intention of them that made it. Now, I'm using those archaic phrases for specificity. Now, what that means is that the only rule of interpretation of statutes is the intention of Parliament. But another thing that we need to know is that where Parliament's intention is clear, the judge has absolutely no powers to alter the meaning of any particular statute. You can sometimes have creativity in terms of how statutes are interpreted. But again, this comes as in England, for example. First of all, it was reading the statute in line with the spirit. Then it changed into reading the statute in line with the letters of the statute. And only where there are issues regarding an accurate translation do you deviate from that. And we said there are two different ways statutes can be interpreted. And that is one, by using the literal rule, and two, using the functional or liberal rule. But again, even the literal rule is beset by certain rules and guidelines. And we said some of those will be that you read in line with what? The meanings suggested by dictionaries, maybe manuals, trade books, etc. And I think we discussed the PDP and INEC matter, where the Supreme Court used the Collins Dictionary to interpret the word to die. I hope you remember.
Yes, sir.
How many of you have read the specific case since we had that discussion? Come on, just one person. Olatoyinbo. Okay, so we go on. We'll come back to it later. And then we said other than that, there's also something called non-scriptural associates, which means that the meaning of a word is to be judged by the company it keeps. And we talked about where there's where there are words like void, for example, voidable, which denote different things, and then they are used interchangeably in a statute, then there's a general appraisal of the whole statute to know whether the word meant is void or the word meant is voidable. Then we went on to also talk about the contemporaneous rule, which is basically that statutes are interpreted within context in terms of time, the currency of the of that specific time when the statutes were made, right? And then, but that there are exceptions to that rule where there can be an expansion of the meaning to encompass new realities. And examples were given in your notes. We talked about the Telegraph Act, for example, that whose meaning, which covered telegraphs, and the meaning was expanded to include telephones when that invention came into being. Or the Engraving Copyright Act, for example, which basically was in respect of engraving, but pictures became included as time went on. Then there's Expressio Unius Exclusio Est Exclusio Ulterius, which basically means that the expression of one thing is to the exclusion of another thing. So where specific things are expressed, we are going to go into the practical aspect during our tutorials for this, where we'll bring in specific sections, and then we can assess the representation of these rules in those sections. Now, where specific things are mentioned, that means it specifically excludes others. And what this basically does is to protect the integrity of the particular section of the statute, so that it doesn't fall into the whims or vagaries of the mind of a judge. And then there's also something called the Adjustem Generis rule, which means things of the same kind. Now, this is almost the Expressio Unius rule. This is almost a converse to it in a way. But the Adjustem Generis rule literally means things of the same kind or nature. And they are normally used when there is an enumeration of things followed by general terms. It could be something like, maybe let me use a non-law explanation. If, for example, a wife sends the husband to the marketplace and says, please buy items like sugar, milk, tea, Bonvita, and any other thing. Now, that enumeration is followed by general terms, meaning any other thing. Will he be entitled, what do you think he'll be entitled to buy under the term any other thing?
Something like Milo
Milo.
or any other profession.
Things that follow that genus, that kind. He can't go and buy a laptop for himself with a credit card, can he? Hello?
We are with you, sir.
Yes, sir.
Okay.
Yeah, with you, sir.
Because a laptop, for example, will not be part of the breakfast items that we're talking about. And that is basically what the Adjustem Generis rule stands for, things of the same genus. Now, we've also said that there's something called the functional rule, right? And for the functional or liberal rule, the functional or liberal rule comes into play specifically in two cases. Number one, when the language of the statute is found logically defective. However, logical defectives may be of three kinds. The first one is where there are marginal or borderline cases. And we say Salmon refers to this as semantic ambiguity. Can someone give us a hypothesis for that? What is semantic ambiguity?
Yes, sir. What
Yes.
I think that word or that particular phrase means is that where the word or the words used by the legislatures is subject to multiple interpretation. So it becomes ambiguous as to what exactly the lawmakers were trying to say with those particular words. So it becomes very ambiguous.
Some of those words become very ambiguous. I'll give you a reason. I think one of the things you had in your notebook will be relating to if you're talking about someone being a driver. If somebody is holding the steering of a car that is being towed, for example, will he be considered a driver? It's arguable whether he will be considered a driver or not. If you are defining, for example, someone who has committed electoral fraud and the statute says something like whoever votes in an election representing himself to be a person entitled to vote, something like that, will be guilty of electoral fraud and shall be sentenced to so and so. Now, if someone impersonated a dead person, will he fall under that rule? He impersonated a dead person. The section says somebody who impersonates someone who is entitled to vote. Is a dead person entitled
Yes, sir. In
to
that
vote?
instance, okay, Shomope, go ahead. That person is not entitled to vote, so it will not count as if he impersonated the person, because for that to count, it has to be a living human being.
Not just a living human being, but a human being that is entitled to vote, right?
Yes, sir.
Who has a different opinion?
I think I have one, because I think a dead person in themselves in a form is a form of electoral fraud in itself. So I think impersonating a dead person would still be fraud.
Impersonating a dead person will still be fraud. Why? Because a dead person is, what did you call it?
Naturally, a dead person should not be able to vote.
Okay.
Yes. So if a dead person, it's a form of electoral fraud, at least in my opinion. It's a form of electoral fraud if in an election a dead person votes. So that should still be some form of electoral fraud.
Okay. But you know, both sides are not too sure, right? I know lawyers don't like saying I'm not really sure. How sure are we?
Yes, these are not so sure anymore, because if it will be meaning fraud, again, it does not really matter. I don't think it really matters if the person was alive.
Now, these kinds of cases are what someone calls semantic ambiguity, and they are likely to be borderline cases. Maybe 100 cases of electoral fraud, you probably just see one or two of these. You understand? And it becomes very difficult to bring them within the specific iteration of the statute itself. That's the difficulty. And that is why they are called semantic ambiguities in the first place. I'll tell you another one. There was a lady in the Greek, a Greek athlete in the Olympics. I think that was probably before any of you were born, where at the time they were using testosterone levels. No, not testosterone. They were using chromosomes to figure out in their tests whether someone was a man or a woman. And this particular Greek athlete was when there as a woman, was supposed to have XX chromosomes, came out in the test with XY chromosomes, which basically the Y chromosome is a particular male chromosome, right? But when she came out with XY chromosomes, it meant, according to the Olympics at the time, that she was biologically male. But she was female. And this was a borderline case. It had never happened before. And increasingly, we found out that we are beginning to have more and more of those kinds of cases, particularly in sports. You have Caster Semenya, high testosterone levels. Why? Because she was intersex, right? You have all kinds of issues where people can have something naturally that goes beyond what was ordinarily thought of. There are people who have their hearts on, you're supposed to have your heart, I think, on the right, is it the left side of your chest? I don't know. But there are people who have it on the other side, you know. So those are the kind of borderline cases. And usually what will happen is the laws will be, depending again on what kind of law that it falls. If it's a punitive law where, for example, people are paying taxes and likely to go to prison and things like that, the response of the courts will be a little reluctance in expanding it. But if it's other kinds of statutes, then the response of the court will be, it will be much easier to expand to encompass it within the meaning. Now, the second one is what he calls syntactic ambiguity, where words, conjoining words, words that join sentences, for example, words like, or, and become a little unwieldy in terms of its being used. Especially when you check the penal code, you find a lot of times they will say somebody is entitled, somebody shall be punished for imprisonment for a term of blah, 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 and fine. Now, these are conjunctive words. But a lot of times, it does not really mean that it shall be a term of imprisonment and a fine. So judges use their discretion to either give a term of imprisonment or a fine, which means different things. Now, in these circumstances, the understanding of interpreting status of a judge becomes key. Why? Because they have to understand the import of the whole statute itself and what it strives to do. And whether, even though a word like and being conjunctive should be treated as disjunctive, like a word such as or. But we'll go through all that as time goes on. And then the third one is where the statute may be so vague that it is difficult to know whether the legislature had any specific intention at all, or whether the legislature was just plain confused and did not know what to do. Now, in these kinds of cases, what the judges will do is to presume an intention for the legislature, upon which it will do its job of interpreting. And I understand that there are processes by the judiciary, particularly for those types of statutes, where notification will be given to the legislature in case it wants to amend those kinds of statutes. Now, we talked about the first type of cases, right? Where we were talking about logical defects. And we said under logical defects, you can have syntactic ambiguity, you can have semantic ambiguity, and then you can have vagueness. Now, this is the second case where, and we said the second cases are those types of cases where the literal interpretation of a statute could result in the kind of absurdity or unreasonableness that makes it clear on its face that the legislature could not have intended what it enacted. This is called the golden rule of interpretation. And it talks clearly about two things: absurdity, unreasonableness. It means the literal reading leads to absurdity. And because of that, you find that a construction is given that more or less changes even the words of the statute. Now, as in Jay formulated this in Attorney General versus Lockwood, where he said that construction leads to a plain and clear contradiction of the apparent purpose of the act or to some palpable or evident absurdity. And a lot of times, some of these sections that lead to absurdity will fall foul of some specific rule of law that has been understood for generations. If, for example, can somebody use the hypothesis in your notes and just explain that to us? Theophilus.
Yes, sir. So the example that we have is in a case where in the case of inheritance that provides that in the case of inheritance, the dead person's relatives would inherit the person's estate. So where, for example, it was those relatives that killed that deceased person, I think it is quite clear that the Administration of Estates Act did not intend that someone that committed murder should inherit property, because basically in that kind of situation, it means that there is a basis that people can freely kill maybe relatives of theirs, their parents, their siblings, their kids in the name of inheriting, and they will still be able to inherit that person or their property. So in such a situation, it wouldn't make sense, it would be unreasonable that someone who killed another person also still inherits that person.
Thank you. I think we have, can you give us this? I think we have another one there.
Yes, sir. The second instance is where we are talking about the assets of a company being transferred to another upon winding up or upon takeover by the other company. Now, it is said here that we cannot say that the workers of the company should also be transferred like that, because they cannot be regarded as chattels.
Okay.
The contract of personal service are not capable of transferred.
Okay. Thank you very much. Another hypothesis, for example, could be if you have a statute, for example, that basically talks about offer and acceptance. Okay. If offer is given for so and it is accepted, then the person who has accepted is bound to pay consideration for so and so. But now, a lot of times, statutes will not take into consideration other overriding principles of law. For example, that any agreement founded on illegality is void, right? So this particular hypothesis I have given would mean that regardless of what the statute says, if the original ownership of that property was steeped in illegality, then the offer and acceptance stipulations will be absorbed in terms of who owns what and who is to pay what consideration. And then we also say that there's also something called the mischief rule. Who can explain the mischief rule as typified by Hayden's case?
Well, the mischief rule, basically, the mischief rule in the case of interpretation looks as, now in Hayden's case, right? There were principles that were laid down, I think 4 things that were to be taken into consideration. But basically, an overview of the mischief case is when an act was created, there was maybe a specific problem, or there was a particular this thing that act was brought into existence for. For example, if there was a problem that was intended to be cured, so that act, for example, let's use the Land Use Act, for example, if the Land Use Act was brought in to unified land holding in Nigeria, then there is no part of the Land Use Act that can then be interpreted as creating a dual system of land holding in Nigeria. And I think this was the position that the Supreme Court has held in like 2 different cases that it gave us, which is Ajilo versus Savannah Bank and also Gerba Abioye versus Saadu Yakubu. But in Hayden's case, the 4 things that that was stated was one, the common law, or why what was the law before the enactment of that particular statute, what was the mischief or the defect in the law which that statute intended directly to resolve, what remedy the parliament gave in the new statutes, and the reason for the remedy. So when appreciating these 4 things, it would allow the court in interpretation of statute to look at the specific problem that was intended to be addressed. And then if they would not interpret that act in a way that is in opposition to the mischief that was aimed to be cured.
Thank you very much. Suleiman, you are raising your hand.
In Aiden's case, I think they were trying to curtail the act of prostitution. Then I think they kind of created it in another area, which they took them to court. Then it was, I think it was the case of prostitution. So I can't remember the case, sorry. I can't remember.
Go and read it up. Now, the Supreme Court in Nigeria has also done certain things, because when we talk about the whole idea in your judicial precedent, we talk about what a ratio is. But when you talk about the idea of the mischief rule, people treat the mischief rule as a functional way to interpret statutes. And some other people treat it as an entrenchment of the literal rule of interpretation. Who has what opinion here?
I am on the side of those that believe it is an entrenchment of literal rule, because ordinarily, literal rule is saying that we should give it its ordinary meaning. We should just give it the plain intention of the legislature. Now, I believe that is what mischief rule is also preaching in a way, because we are still looking at the intention of the legislature at the time of making the law. So I believe it is just like an entrenchment.
Okay, so yeah, if it's not trying to change the words of the statute or use the spirit of the statute as a mode for interpretation, then it is still an entrenchment of the literal rule.
Exactly, sir.
Okay.
Yes, sir. I have a different opinion, sir.
Okay, go on.
Yes, if we look at the literal rule very well, we'll see that it actually deals with the words used in the statutes. Whereas mischief rule is saying that look beyond what is written in the statutes. That is, look at what problem the statute has been brought into existence to resolve. So if you say it is an entrenchment of literal rule, maybe although it may look like that, but it is not that it is an entrenchment of it. So that's just my opinion. Literal rule is dealing with the words used in order to get the intention of the legislature. However, the mischief rule is saying that look beyond what is written and interpret the statute to in line with the mischief that the statute has been brought into existence to resolve. So that's just my thing.
Ola.
Yes, sir. So, from my understanding, the mischief rule is actually, I would say, it's an entrenchment of literal rule. Why? Because first, we must understand that all forms of interpretations are meant to interpret to the extent of the intention of the legislatures. So, coming to this, we understand that the literal rule would look plainly at what the legislature legislature says, the words of the law itself. But then mischief rule goes beyond that, in the sense that regardless of whatever is contained in the body of the laws, the court still needs to make an form of go on an escapade, historical escapade, to determine what was the mischief before the enactment of the act and what the legislature actually intended to cure. For instance, the Hayden's case that happens to be the Logos Classicus case for this. Like Kabir rightly said, it's a case of prostitution. They were trying to eradicate public prostitution. But since the public prostitution was publicly prohibited by the bodies of the legislatures, then the prostitutes devised other means, such as going to the windows of prospective clients to advertise themselves. So this was discovered as well, and it became an issue as to, do we also regard this as a public prostitution? So the court had to go and escalate to determine that what was the purpose of the particular legislation that prohibited public prostitution, and it was discovered that the particular acts or the other means that was devised by the prostitutes also fall within the purpose of what the legislation was trying to prohibit. So for that reason, it was made to also cover that particular circumstance. So with this, you can see that it has gone beyond literal meanings, but then it extends into, yes, it extends into the purpose, which is also in a way trying to investigate the intentions of the legislatures as at the point of making the legislation. Thank you, sir.
Abdul Rashid.
Thank you very much, sir. Now, I believe we are getting the case of the Aidens case wrong. Now, the intention of the legislature at the time was to curb a particular disease. And the disease, it was discovered by the legislature that it was as a result of prostitution that was rampant at the time. Then that was why they made the law. Now, after they made the law, of course the law was not enough to curb the issue of prostitution in the first place. And what was the intention behind it? It was to ensure that there was no disease anymore. So that was the reason why they had to come with that remedy. Now, on the face of it, as agreed by Allah Mahad, my lord, he agreed that the major purpose of interpreting the law itself is to discover the intention of the legislature. Otherwise, we are going to be the judiciary are going to be usurping on the powers of the legislature. Now, if something is now saying that, okay, you should take a voyage, the reason for that voyage was to discover the intention, the major reason behind it. And literally saying that, okay, you do not need to discover this anymore because it's already plain on the words used. So I believe it is just an entrenchment.
Okay, thank you. Theophilus.
Yes, sir. So building on what Tunji Lawal has said, I think why we can't say the mischief and literal rules are intertwined is that you have to look at how they are used and how they function. That is in the sense that the mischief rule, right, allows, the literal rule is just take the word as it is, right? Even though there is a connotation of, oh, you have to look at the intention, but it's not really there. At the end of everything, it is just how is the word defined in dictionaries or textbooks or manuals. That is the literal rule of interpretation. However, the mischief rule, I think, out of everything, it's far more flexible because sometimes the words used, as we said earlier, can give some form of ambiguity. It can be interpreted either ways. Now, if we're using the literal rule there, that ambiguity, and for example, the example that you gave us in class when they were talking about the governor left his position to go and become vice president, and then in the terms of in the process of interpreting, they interpreted debt as anything other than debt. Now that is literal rule. Now, if we were to use the mischief rule, it would go beyond what the word is used, because sometimes the word can give ambiguity, and this is where the mischief rule separates itself. That is, it goes and look at what was the specific problem, what was the situation at that point in time in which that act was brought in for, and what was it trying to handle. Then, thus, following that procedure, they would now use that. So in a way, good and fine, I do agree with Shumupe that it makes the judiciary have a lot of power in terms of making it look like it is a lawmaking body, but not really. In a way, it allows the court then in that particular situation to be able to interpret that statute in line with the problem that was targeted in the first place, because using the literal rule in that particular case would just not be sufficient. So the literal and mischief rule are not connected in that way, because of the literal rule in that particular place is now subject to a lot of mistakes because of wrong interpretation of maybe specific words, giving the death case as example, while the mischief rule allows it to go beyond and look at what the specific thing is and then interpret the statute in line with solving the problem that was intended to be solved in the first place. So they are really not linked to each other, or it cannot be considered that the mischief rule is a part of the literal rule.
Okay, thank you very much.
Yeah,
Let's
yes,
see
sir.
what Kolato
Yes,
is
sir.
have to say.
Yes,
Kolato,
Yes, sir.
Thank you very much, sir. To me, mischief rule is not an infringement of rituals, and they are connected. Why? Mischief rule is a rule of interpretation which is the effect that a status is interpreted in such a way as to remedy the defect. Sir, it is the reason why I can say it is an infringement is
you have a lot of background noises there. You can hardly hear you.
okay, sir. In mischief rule, we are just trying to ascertain the intention of the legislature and nothing more. We are trying to discover the meaning of the letter used. So we can't call it an infringement. It is just a way of interpreting. It is a literal rule. It's a literal rule, but we are just trying to discover the meaning of the letter.
Okay. Thank you very much.
Yes, sir. Yes, sir. Thank you very much, sir. In order to just give an example, to cite an example in support of what Theophilus has just said, sir. If we look at the Land Use Act, it was brought in order to cater for unification of land holding system in Nigeria. So in that act, there is a particular provision which is to the effect that whenever there is going to be any transaction on a land which the governor has actually granted a statutory right of occupancy, so the consent of the governor must be sought before such a transaction can be done. So there's now an issue in the case of Savannah Bank against Ajilu on whether or not this particular provision applies to deemed right of occupancy. So it was in that case, if we are to go by the literal rule, there is nothing in the provision, in the letters of the statute, in the letters of that particular provision in the Land Use Act, which is to the effect that it can also apply to deemed grants. So the court now went on to use the mischief rule to say that although there is nothing in this statute that is stating that any a land upon which there is a deemed right of occupancy, that consent of the governor must be sought. However, in as much as the mischief that the Land Use Act was brought into existence to resolve is the unification of the landholding system in Nigeria, then it means that the act could not have set out to provide for for a dual system, of landholding in Nigeria. Because if the act allows that a consent should be sought for actual grants, and the act does not allow for consent to be sought in deemed grant, then it means that the act itself is bringing another problem which it has been brought into existence to resolve. So it was the mischief rule that the court used in that case to say that although in the letters of the statute there is nothing pointing to the fact that consent of the governor must be sought for deemed right of occupancy. However, since what the Land Use Act was brought into existence to resolve is the dual system or the different systems of land in Nigeria, then it means that it should the interpretation should be given that the section also applies to deemed right of occupancy. So it's just an example to what Teofilo said, sir.
Okay, thank you. Samuel.
Yes, sir. I'm supporting Shumafe Abdul Rashid on this, and my argument is on the word entrenchment. Like when we say entrenchment, we mean to broaden, to widen the the literal meaning of the rule. Like mischief rule is to clear any mischief I might have arised. Using mischief rule does not bring any changes to the literal rule. It does not give changes to the literal, but only just extend the literal rule. So that's my point on that.
Okay. Thank you. Aziz Isiaka, you have something different? Aziz Isiaka.
Oh, hello, sir. Good morning, sir.
Good morning. How are you?
Fine, sir. Sir, the argument that mischief rule is entrenchment to the literal rule does not stand, and here is my stance. Mischief rule has come to correct the mischief in the status in which the status has at that moment. But when I say literal rule is very clear. It's just to interpret the provisions of the law as it is in accordance with the intention of the lawmakers. And mischief rule will be resorted to only when literal and or golden rule of interpretation would lead to an ambiguity or mischief that makes the intention of the legislation uncertain. Before the court can resort to mischief rule, the court has to look back to the history of the law and try to correct the mischief the law has brought in place. And thereafter, the court will now be able to arrive at just interpretation. But mischief rule goes beyond interpreting the law, literally. Like before the court can correct the mischief, the court has to go beyond ordinarily. And literal rule deals with interpreting the law ordinarily. That's my stance, sir.
Okay, thank you very much. Let me just round up by saying, number one, when we talk about interpretation of statutes, we've been using the word interpretation all along for this class. Why? Because I didn't want a confusion in terms of what we call interpretation and what we call construction of statutes. Now, these two terms, construction and interpretation, are used interchangeably. Okay? The reason they are used interchangeably is because obviously they talk about interpretation, learning the meaning of words and phrases. But there are two different ways that you learn the meaning of words and phrases. Number one is that if the words are understood by the reader, they are clearly understood by the reader. What the reader does is just to interpret it. And on the other side, if the words have some issues in terms of a clearer explanation of what it says, then what you do is construction. And the reason you construct is because you are trying to construct a meaning of the words and phrases of a statute or the sections of a statute. And for you to construct, you must first of all deconstruct. Now, if you are deconstructing, that is where you now say, okay, we did something like that earlier in the semester where we talked about syllogism. Every Nigerian is crazy. Then you say, are you a Nigerian? If you are a Nigerian, then it means that you are crazy. And we did that syllogism. Now, as part of that exercise, we did a little deconstruction. where we now said, okay, what is the meaning of Nigerian? What is the meaning of every Nigerian? What does crazy mean? Now, what you are doing is deconstructing. You are removing the blocks of the sentence to look at each and every one, what it means, what is the import of each and every word. Then you put them together as phrases and then interpret. And the general perception is, if you're having to do that much, then what you're doing is construction. If you don't have to do that much, why? Because the words are simple and in line with what you assume to be the intention of Parliament, then the only thing you are doing is interpreting. Now, from our discussion, I'm beginning to understand that where you are doing more than interpreting, interpretation will lend itself to a literal rule of interpretation. Construction will lend itself more to a functional or a liberal rule of interpretation. Am I correct?
Yes, sir.
Yes, sir.
Yes, sir.
Yes, sir.
Yes, sir.
Party to disagree with me. Now, if that's what we're doing, then that could give us a path into understanding whether the mischief rule, for example, is a further entrenchment of the literal rule. But a basic rule is always that the constant thing is the search for the intention of Parliament. Why? Because that is the rule that judges are sworn to. Every other thing that is done is still in the process of finding the meaning of Parliament. And the functional or liberal rule are not the main rules. They are rules subject to the failure of the literal rule. I hope we understand all that.
Yes, sir.
Okay, then you can continue with your argument. Let's move to the next slide. The next slide basically is that I'm going to rush through this for what we're going to do with the judicial precedent. Then we may come to our physical, maybe when we have our physical class and we are doing tutorials, we run through that again. What is judicial precedent? The speed with which we switch from legislation and interpretation of statutes was too fast for you?
Not exactly.
Okay, I'm just collecting your thoughts.
Okay, judicial precedence is just a situation whereby an inferior court is bound by the decision of a superior court, and it becomes a law that is followed by the inferior courts of the same class.
Okay. And what is judicial precedent hinged on?
Stare decisis.
Okay. Okay.
Sir.
Tunji,
Go on, Isiaka, go on.
It hinges on hierarchy of courts, like hierarchy of courts.
Thank you. It hinges on the hierarchy of courts, right? So when we say it is being understood in two different ways, in its loose sense and in its strict sense, Theophilus, what do you think that means?
sorry, my mic was muted.
Okay.
I think in the loose sense, right, that would in a way that is I think more of it deals with persuasive versus binding judicial precedents. So I think in the loose sense, it's going to be more of you are allowed to cite the case before a judge, right? That this is similar to this case. That means a previous case, or maybe this part of the case is similar. So judges can choose to follow it based on their ability. For example, if it was a decision of the Supreme Court and cases before the Supreme Court, the court is allowed to depart from that decision. But however, I think in the strict sense, this deals more than just it is their choice to follow it or not, but in the strict sense, it is that it is binding. So, for example, this is where the hierarchy of courts come into place. The Court of Appeal would not be allowed to depart the decision of the Supreme Court except in specific instances, i.e., if they can show that the case the Supreme Court decided was is different in certain ways from the current case they are currently facing. So in that sense, they would be able to depart. But I feel in the strict sense, it deals with that subsequent courts are bound to follow it. So in the first one, it's more of persuasive on them, and this one, it's more of like binding on them. I think that's what I get from the loose and strict sense of judicial precedents.
Okay. So if you are calling the precedent, for example, and it's just persuasive, will it be a precedent?
It be a precedent because if we're looking at this thing at the ending of everything, it does set a form of pattern, right? Or a form of in a way, a form of prior knowledge. Although it is not binding, but it is still a precedent.
It's still a precedent in a way for, at any rate, it's a precedent for lower courts to that particular court. And it's also a precedent because it compels, if it's of a court of coordinate jurisdiction, it's still a precedent because it is one of the several tools you can use that can that you use in reaching your own decision. So it compels superior reasoning, right?
Yes, sir.
Okay. Now, the Latin maxim, stare decisis et non quietam mover, basically means that courts are to stand by their decisions and not disturb the undisturbed. The process of judicial precedent is predicated and founded on the following. We talked about the hierarchy of courts, right? But one thing we need to know is that judicial precedent is specific, is one of the distinguishing factors of common law legal systems. We talked about the civil laws in Europe, for example, which does not necessarily follow a system of precedent. But there are three basic things that judicial precedent is founded upon. One, like one of you said, is the hierarchy of courts and the appeal system, right?
Yes,
Can
sir.
someone explain that for us? The hierarchy of courts and the appeal system.
Okay, sir. By hierarchy of courts, it's simply talking about that where decisions move from the lower courts and being appealed to an higher court. So, nonetheless, decisions of the higher courts binds the lower court in cases that shares similar facts, or do I say almost similar facts, because no two cases are the same. But then where a lower court is faced by a decision of an higher court on a fact that is almost similar to decision that has been made by the higher court, and the lower court is bound by that particular decision. For instance, the decision of the Supreme Court is binding on the Court of Appeal, regardless of whatever the Court of Appeal thinks about it. If the Supreme Court has made a decision in a particular way, the Court of Appeal is bound.
Okay, we get what you're saying. Then the second one is, thank you. The second one is legal principle. Because again, the legal principles must align.
Changes.
And the third one will be the similarity of reasons for decisions arising out of the similarity of facts. The facts may not be exactly the same, but there are legal principles that are based on the facts, and the facts are similar. Murder, for example, will remain murder. But someone can be murdered in the evening and another person murdered in the morning. A man can murder a woman and a woman in another case can murder a man. So you will always have those differences. Now, the vertical precedent is basically where the focus is on the upper court, in which case you are bound. And the horizontal precedent will be courts of coordinate jurisdiction, which basically will mean that they are of persuasive effect and that you will give due consideration to them. They don't bind you, but you will give due consideration to them in the process of justice delivery. Now, a decision of a court of coordinate jurisdiction is not binding, and such decisions may either not be followed or may be distinguished on some ground. The distinguished decision does not lose its authority so far as the subordinate courts are concerned. We are still saying the same thing. So we say in English law, there's a recognition of the following as persuasive. One, the decision of the superior courts in America, particularly the Supreme Court, the decisions of the courts of the Commonwealth, which generally follow the legal principles of English law. When I was at, during my undergraduate years, because a lot of the growth of the Nigerian legal system and the principles of law within that jurisdiction, I think happened over these past 30 years or thereabout, particularly in terms of interpretation of the penal code. The Sudanese penal code had a lot of mileage in terms of how the penal code was interpreted. And a lot of cases were used from the Sudan in terms, especially when you're talking about things like whether the reasonable man within our own penal code was an objective or a subjective reasonable man. So basically, that is what we're talking about when we're talking about decisions of courts of the Commonwealth. We generally follow legal principles of English law at the time. Then the decisions of the Privy Council, which though are authoritative, for the colonial courts, but like we said, are persuasive for the courts in England. Indeed, the legal writings in authoritative works have only persuasive effect. We've seen this again in international law, where they are treated as sources of international law, but probably have more mileage in terms of importance than they do in domestic law. Now, there are circumstances that may weaken or completely destroy the binding force of precedent. Some of these are: one, inconsistency with statutes. No matter what kind of court you are, if your decision is inconsistent with statute, then it will lose its authority. And I think, again, that is one of the ways you show the function of the legislature as the apex lawmaking body. Two, it may be overruled or reversed by a higher court. A decision of a lower court may be affirmed on a point that is different from the one which the lower court, upon which the lower court reached this decision. Who can explain that?
Wait, sorry, sir, please, can you come again quickly?
A decision of which one? C?
Yes, sir, the last thing you said.
Okay, a decision of a lower court may be affirmed on a ground or point different from the one on which the lower court reached this decision.
Yes, okay.
I think if I'm allowed to go, in that particular case, what it's saying is sometimes I'm trying to find an example, but sometimes a lower court might rule in a particular way and then give their reasoning for ruling that way, right? And then if it goes for appeal before a higher court, right? For example, if the case of the Federal High Court goes to the Court of Appeal or the Supreme Court, while they would hold that the lower court held rightly, that is the trial court held rightly, they might give a different reason than why that court held rightly. For example, I'm trying to think of an example. For example, let's say in a matrimonial causes act, in a matrimonial causes case, in the case of where the person died intestate, right? And they made a ruling, for example, towards the administration of estate and for the probate court that specific persons could not inherit because of their position in law, right? And let's use the example that the relatives were the person that killed the deceased in this case. The higher courts can agree that maybe those specific persons can't inherit, but however, the reasoning that they would give would be different than what the lower court gave. So basically, they are still agreeing with the lower court, but however, the reasoning has changed.
Thank you very much. I think that's basically what I want. They are not disagreeing. They are just saying the reason has changed. And what that does is basically to destroy or weaken the force of precedent. Because now the lower court, when another court follows that precedent, it has to follow that precedent on the basis of the reasoning given by the higher court. Now, again, we said a decision may lose its authority if it was given in ignorance of any applicable or binding decision of the higher court, or D, if it was given in ignorance of a statute or a subordinate legislation, for example. So we can keep going down, and we say sometimes the court may give a decision sub silentio on a given point if the decision was not fully argued before the previous court. Okay, Tunji. Tunji, go on. Who can explain sub silentio?
Hello, sir.
Go on, yeah.
Can you hear me now, sir?
I can hear you.
All right, sir. Yes, with regards to that, sir, I want to ask that, for instance, where there is a court of appeal decision, and that decision, we know it is binding on the lower courts, and it's a form of it's a judicial precedent to them. So maybe before the case is appealed, or before the judgment is appealed against to the Supreme Court, then it is a binding precedent for all the lower courts, and they've been using it. So in a situation whereby the Supreme Court, when the case now gets to the Supreme Court now gives the same judgment, maybe upholding the decision of the Court of Appeal, however, giving another legal reason. In that wise, are we going to say that it is only the legal reasoning of the Supreme Court that will now become the binding precedent of that particular decision, or that of the Court of Appeal will also constitute a binding precedent, just like it were before?
Who has an answer for him?
I think if I can answer that, in that particular scenario, right, for the period in which the case was still in litigation, or let's say in appeal to the Supreme Court, the decision of the Court of Appeal and its reasoning was going to be what is binding. But however, even if the case now went to the Supreme Court, and after where the Supreme Court upheld the Court of Appeal's ruling, but it gave a different reasoning, the reasoning of all the lower courts would have to align to the Supreme Court's reasoning, which means in that particular case, the Supreme Court has basically erased the reasoning of the Court of Appeal and replaced it with its own as the basis for why that case should be held. So if the lower courts now have the Supreme Court's reasoning, instead of applying the Court of Appeal's reasoning, they would use the Supreme Court's reasoning instead for deciding cases in a similar manner.
That's basically my opinion.
All right, sir.
Now, for H, where an appeal court is equally divided, the doctrine of semper presumptor pro nagante applies. In such circumstances, the House of Laws holds that the decision appealed from becomes that doesn't normally happen because we normally have, I think, a 5 Supreme Court. That disturbing. So, what that does is where there's the justice of the Supreme Court are hung on that particular decision, then it means the decision given by the previous court, I think it's just common sense, prevails. Now, erroneous decisions such as those given contrary or repugnant to a fundamental principle of law. We're talking about when something is illegality, for example. We're talking about someone having the opportunity to inherit from a relative that he killed and all that. And I basically talks about that. Now, for the hierarchy of courts, who can give us a brief summary on the hierarchy of courts and how it works?
Hello, sir.
Hello, go on.
Yes, sir. On hierarchy of courts, sir. So it simply it is like this, sir. Like we have the Supreme Court as the apex court in Nigeria, followed by the Court of Appeal. So where there is any decision of the Supreme Court, it is binding on all the courts below it. So the Supreme Court is followed by the Court of Appeal, and after the Court of Appeal, we have different courts that have coordinate jurisdiction, such as the Federal High Court, the High Court, the National Industrial Court, and I think Court Martial. So they are all courts of coordinate jurisdiction after the appeal court, after the Court of Appeal. Then after them, we have the magistrate courts, customary courts. They are also on the same cadre after the High Court, Federal High Court, and then we have some other lower courts and behind them, like the area courts. We have the upper area court before the area court and like that. So it simply means that where there is a decision of the Supreme Court, it is binding on all these courts that we have mentioned. When there is one given by the Court of Appeal, it is binding on all other courts below it, but not on the, it may be a persuasive precedent for the Supreme Court. And where we have the decisions of Federal High Court, High Court, and all others in the same on the same cadre, then their decisions are also binding on all other courts below them and not on the one be above them. So like that, that is just what I know about hierarchy of courts.
Thank you. I think basically that captures it. Now, for ratio decidendi, we say ratio decidendi means the ground or reason for a decision. And several methods have been devised for determining the ratio decidendi of a case. Two are worth considering. Now, class rep, I'm going to send a link to you now for further reading on this.
All right, sir.
But let's go on. Do you still have okay, now there are many ways of trying to get the ratio decidendi of a case. Now, why is ratio decidendi important? Olalawa. Whoever can answer us, please, just go ahead. Why is ratio decidendi important?
All right, sir.
Okay, Tunji, go.
Okay. Yes, sir. Ratio decidendi is very important because it constitutes the principles upon which the decision of the court is based. In a judgment, we will have a lot of facts or reasoning that the judge has actually given basically for holding that particular decision he has held. However, there are some principles of law which in the course of him writing those judgments, that judgment, these principles are the basis for his decision. So ratio decidendi is very important because it constitutes the principles of law upon which the decision of a court is on.
Now, and then again, as a spin-off, it also basically helps. That is the most important factor for the indexing of law reports, which we use as tools, right, for representing our cases in court. Because some of you will probably live here, and the first thing you do, I'm sure if there are some law offices that do a lot of publications of law reports and all that, one of the key things that you do is the itemization and indexing of the decisions. And it follows the whole idea of what you call a ratio. What is the reason for this particular decision? And then it is itemized so that it makes it easy for lawyers to index. And by indexing, it means you can basically go straight to that particular principle of law, read it in relationship to its facts and what decision was given. And that is one of the reasons it's so important. Now, we said there are ways for determining the ratio of a case. We'll treat two here. One of them is what you call the reversal test, and some of them also call it the Wambach test, because Wambach was the one that came with what he thought was the reversal test. And basically it means that the ratio is a general rule without which the case would have been decided otherwise. Can I have an explanation? A general rule without which the case would have been decided otherwise.
Yes, sir.
Go on.
Yeah, this is saying that if not for the general rule or the principle that was considered by the court wouldn't have decided the case in that manner. For instance, if you say Mr. A, or if Mr. A is being charged of committing the offense of theft, if the court is going to come to the conclusion that truly Mr. A is guilty of theft, the court must have put certain things into consideration, certain principles or rules of law into consideration before arriving at the conclusion that Mr. A is guilty of theft. So if the court had not considered those things, the court might have ruled or might have concluded differently or otherwise. So that is why that is what I simply understand by the reversal test.
Okay, now let me give you an example too. When you talk about when somebody comes with a defense for insanity, the general rule for proof of insanity would be that A, who is the accused person, did not know the right or wrong of what he is doing, right?
Yes, sir.
Now, that is not a medical rule or a psychiatric rule for insanity. That is more of a legal rule for insanity. Now, what are the ways you can prove that he did not know the right or wrong of what he's doing? When he killed the person, he stood over the person's body and did not try subterfuge or camouflage or to run away or whatever. And he's there still, probably still beating. Now, the law has in mind someone who is out and out insane. Now, if that is a general rule, that he did not know the right or wrong of what he's doing. Now, if you come with a decision based upon that, if you negate that rule or reverse it, and the negation or reversal of that rule will be that, number one, the negation will be that it does not matter whether he knew what he was doing was right or wrong. That is negation. Or you completely reverse it. Would the decision still be different or not?
Yes, it could have been different if the court had thought that he was actually aware of what he was doing. The court would probably not have upheld the defense of insanity in that instance.
Thank you. The moment you make that decision to reverse, and the eventual decision of the court in your mind would have changed, then what you have done is you have just isolated a ratio, which is the ground or reason for a specific decision. I hope this is understood.
Yes, sir.
Very well, sir.
Thank you. Then for the second, and we said Warburg was the key person that championed this. And the second one is what you call the material facts test. And that means that the ratio is to be verified. I'll read it out to you. The ratio is to be verified by ascertaining or isolating the facts considered material by the judge along with his decision on those facts. Again, now you are not, the first one is talking about legal principles. The reason for making a decision will generally be legal principles. Now the focus is on facts considered material by the judge, upon which he's making his decision. And if he's doing this again, you are basically isolating the ratio. If you look at your penal code, and I think there were some annotations on the penal code where there are specific elements of every case. Obtaining by false pretenses, we'll assume that you want to obtain, you obtain by a false representation or whatever. You wanted to obtain by, for the reason of personal gain, and all those are material facts that must be proved, by the prosecutor in court, right?
Yes, sir.
Now, if you are making a decision based on this proof, then all the decisions made based on these elements can now be seen basically as a method for isolating the ratio in a particular matter. Now, we said precedence may be avoided by one, distinguishing. You can distinguish it and say this matter was in respect of so and so and so, and not so. Then you can overrule. A decision can be reversed. You can say that a decision was given par incuriam. What does that mean?
Error or in without consideration of certain principles of law.
Thank you very much. So we'll move to the next one. Another one which is similar to distinguishing is explaining. You can explain a decision. And that explanation can further limit its use as a precedent. And the sixth one is obiter dicta. Who can give us that too?
Obiter dicta is just a statement made while giving the ratio decidendi. They do not have the force of law, as they will not be what would be laid down as a precedent, as we all know that it is the ratio decidendi that is actually the precedent.
Thank you. Now, in decisions where, for example, now when we're talking about judicial precedent, we said number one, hierarchy of courts. The second thing that was very important was the principle of law. And then the third one was how those principles of law ties to the facts. Now, in trying to arrive at a decision, a judge or an appellate judge can arrive at a decision and say, but if the matter had been like this is the decision I would have given. While it is good for academic reasons, it does not form ratio. Why? Because that particular statement by the way does not attach to the facts or the principles of law of that particular case. The person is just making a statement saying, if it was this way, and that becomes an obiter dicta, a statement made by the way. Now, how do you distinguish between ratio decidendi and obiter dictum? Number one is the principle of law. If you look at the specific principle of law, and then you realize that sometimes a lot of obiter dicta could be by way of analogy. This is the principle of law that we are applying, but we would have applied this if this had happened. So you look at the principles of law, then you look at the facts of the case, which will also be distinguished in some manner, because he's saying if so and so thing had happened, we would have applied so and so thing. And then you look at the linkage between the facts of the principle of law and the facts of the case. We will still go through some of these. Now, the advantages for judicial precedent is one, certainty. Two, that there's uniformity. Three, by way of all these explaining, distinguishing and all that, it still has the right amount of flexibility in terms of how you follow even the decisions of courts of higher jurisdiction, of superior jurisdiction. Then four, it is practical because it is fact-based. It is based on fact. The principles of law that are pronounced upon are based on facts. Five, it saves time. Because a lot of times, one precedent is more than enough. When Attorney General Abia State and Attorney General Federal Government of Nigeria talked about how you interpret the Constitution, the rule pronounced on was that because of the special nature of constitutions are interpreted in a loose and liberal manner. Why? Because constitutions are seen as something of a skeleton. And because of that, it needs expansive interpretation for it to be, because constitutions are not strict. So strict interpretations, constitutions are not strict in terms of the wordings. They are not drafted like other legislation are drafted. Because of that, a strict interpretation of constitutions will not bode well for justice delivery. Then it also gives you voluminous cases upon which you can find compellability. It's like someone who has malaria and has 5 6 different treatments that have been given to somebody. They've given somebody ARC before, they gave another one chloroquine, gave another one quinine, gave another one agbo and herbs and all that stuff. That is basically what judicial precedent does, because it gives you options and then it compels you to use superior reasoning to pick the best option. Now, again, there are disadvantages. One being the isolation of the reasoning of a decision, which may be difficult, as we've just discussed now. And then the volume of case law. Case law, there are thousands of cases. A lot of them, the counsels for litigants may be unaware of. 3, there can be injustice in individual cases. We discussed that Anate matter versus Abubakar Sanusi and others. Then it also engenders a slow development of the law. Why? Because you have to wait for cases to come before decisions can be made. There is delay in matters finding their way to court or reaching appellate jurisdictions of courts, and that there is ability or capacity to avoid an inconvenient precedent. We have found out that you can actually even avoid an inconvenient legislation, not even a precedent. And we have had that discussion. Any comments before we close up? Aziz.
Hello, sir. Good afternoon, sir. Good morning, sir.
Good morning. How are you?
Fine, sir. Oh, like I want to ask a question. Like, can a precedent change a clear provision of law?
Can a precedent
change a clear provision of law?
Not at all, sir.
Because you see, like, because in evidence acts, the law is very clear in section 104 that the only admissible, admissible original P.
Hello.
But now, in practice, the law, like the court has ruled in the case of Kazim against the state, that original copy of the public document is also admissible. Now, a case law now is now changing the face of the law, because there is nowhere, it is not contained in the Evidence Act that original copy of a public as document should be admissible. Now, in that regard, a precedent, a case law is changing a clear provisions of the law.
I think it depends on, okay, Aziz, can someone else?
Yes, sir.
Go on.
I think Movi, do you want to speak? All right. I think in that particular case, it is not, for example, what you have cited now, it is not changing the position of the law. It has merely expanded it, right? For example, what we're saying now is that the law provides for this thing to be tendered into evidence, but it's also saying that is CTC can also be given in place of it as well. And that is in recognition of that there are certain instances in which the original might not necessarily be available. So thus, if that document is mandatory for that particular case to move forward, the court can't now kill the case on the basis of a technicality. So rather, it is not changing the position of the law, it is expanding it to certain unforeseen situations that might not just be provided for, which is what I think the court simply did in that situation.
Hello, sir.
So which rule of
Hello, sir.
you think was applied in that case?
Hello, sir.
Hello. Would you
Sir,
okay, go on.
I think the case law changed the law because because in that provision, the law is very clear that only certified copy is admissible and no other. And no other. Express mention of a thing is to the of another thing and no other. So and now there's not a case that says that
I can't hear you. But what I'm going to do, we are going to continue the discussion in class. Okay? And our time is up. So I'm going to wrap up and close our meeting for today. Hopefully by Friday, we should be able to get better discussions regarding these issues. So thank you very much. I came in for my intention was for us to have a seriously interactive class, and I think we basically succeeded. And I'm absolutely happy. Have a nice holiday.
Thank you, sir.
Take care.
Thank you,
AZ,
sir.
wait after the class. AZ, wait. What are you?